All right, Mr. Munoz, who is your client? All right, Edgar Jimenez, come on down, please. All right, court is calling 2024 CR 1357, State of Texas versus Edgar Jimenez. Could I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Renee Munoz on behalf of Mr. Jimenez.
And are you Mr. Jimenez?
Yes, Your Honor.
Counsel, have you received all the discovery and did you review it with your client?
I did, Your Honor, and I did.
Court will find that the state is in compliance with discovery. Mr. Jimenez, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor, I did.
Showing you the true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor, I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Jimenez, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it?
Yes,
Did you
Your Honor.
sign it in all the appropriate places?
Yes, I did, Your Honor.
All right, did you understand you're charged with assault, family second offense? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
I understand, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
I understand, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes, I do, Your Honor.
Counsel, is this only an application for regular?
Yes, Your Honor, application for community supervision, straight.
All right, counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, that is correct, Your Honor, and I do attest to being correct as well.
Mr. Jimenez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, I am, Your
Are
Honor.
you a U.S. citizen?
No, Your Honor. I'm not.
He's not a U.S. citizen, Your Honor. I spoke to him and he stated that he did seek immigration consults before, and he was advised by an immigration attorney as to the possible consequences of a plea as to this offense. Today, I did ask him if he had any further questions. He said no, that he had been advised previously by an immigration attorney and doesn't have any questions regarding possible consequences that had been previously addressed by that immigration attorney.
All right, did you have sufficient time to speak with an immigration attorney?
Yes, Your Honor, I did.
And is that immigration attorney you spoke to, were they aware of these pending charges?
Yes, Your Honor, they were.
Were they aware that you were going to be entering a plea to assault family second offense?
I made it known to them that I would take what was available to me, Your Honor. So,
All right, so were they aware?
I haven't spoken there. I don't guess they weren't aware.
Your Honor, we got the plea offer today, but the immigration attorney did state that if there was a finding of guilt or it wasn't deferred or was deferred, that they could have certain consequences as per him pleading guilty on this.
All right, so you're aware that by entering a plea into this cause, that you could be deported? Are you aware of that?
I understand. I'm aware, Your Honor.
And you understand for immigration purposes, this is a violent offense?
Yes, Your Honor, I understand.
All right, and are you aware that you could be denied re-entry into the United States? And are you aware that you could be denied naturalization?
I'm aware, Your Honor.
Knowing that, do you still wish to enter a plea into this cause number?
Yes, I do, Your Honor.
All right, and counsel, do you feel that your client understands the consequences of entering a plea into this case and the impact it will have on his immigration status?
That's correct, Judge, yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea, punishment is to be assessed at 6 years in the prison. The state recommends community supervision. There's an affirmative finding of family violence. There should be a mental health evaluation following those recommendations. There should be no contact with Graciela Jimenez. Did you understand that to be the plea?
I understand, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, I did, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I understood, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 6 years. Did you understand that was a recommendation from the state and the court does not have to follow those recommendations?
I understand, Your Honor.
And did you understand with an affirmative finding of family violence, if the court finds that this is an affirmative finding of family violence and enters that, then you will not be allowed to possess or own any weapons or ammunition? Did you understand?
Yes, I understand, Your Honor.
And did you also understand that you would not be allowed to be designated as primary custodial parent?
Yes, Your Honor.
Perfect. Then to the offenses charged, how do you plead?
No contest, Your Honor.
State any evidence.
Yes, Your Honor. State offer states one and attachments.
No objection for the defense.
Right, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
I understood, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
I understand, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
If we may, Your Honor.
Anything you wish to say on behalf of your client?
Respectfully ask the court to follow the plea bargain agreements as per the offense report, and my client's accounting of the events stated that he had been intoxicated on alcohol that evening and unfortunately mixed it with Xanax, which caused him to kind of black out. I did notify him and strongly advise him to be careful about mixing any of those things of that nature. That he's going to be on probation, so he cannot consume any alcoholic beverages or ingest any kind of drugs that are not prescribed to him by a physician, Your Honor. He states that he does not regularly ingest alcohol to that degree, but on this evening kind of went out of control and caused him to be arrested and subsequently confined for the last 5 months since his arrest, Your Honor. So we're respectively requesting that the court follow the plea bargain recommendation and allow him to be supervised in the community in lieu of prison time.
All right. Do you have any children?
Yes, Your Honor, I do.
How old are they?
She's 12.
And who is she with?
She's with her mother.
When's the last time you saw her?
A month before my incarceration, so 6 months.
All right. Have you been employed before?
Yes, Your Honor.
And what type of work?
Landscaping and a kitchen remodeling,
How old are you?
30.
And what's your drug of choice?
Prescription pills.
All right. This is what the court is going to do. Court is finding you guilty. The court will sentence you to 6 years in the prison, suspended and probated for 6 years. The BIPP course, affirmative finding of family violence. There's to be no contact with Graciela, Graciela Jimenez. There's to be no contact with the following persons: Jesus, Daniel, Sierra Gomez, Germina, Germina, Barrocal, Berrocal. And there's to be no contact with Fratelli, Farattelli Road in San Antonio, Texas, with the zip code of 78233. There's going to be field visits 1 time per month for 3 months. And then at probation's discretion, and there's to be no unsupervised contact with minors. And did I already say report by Zoom or in person? All right, report by Zoom or in person. I'm going to want the UA hotline, a TAP evaluation while in custody, follow TAP recommendations, The 200 hours of community service restitution, that will be waived once you complete parenting classes. Proof of employment within 30 days. No employment as a home health care provider with minors. Anything else, probation? Is there anything else you need from the court in order to be successful?
Thank you.
All right, you're welcome. And I don't know if felony drug court would accept him on the based upon the nature of his offense, but
Yes.
counsel, if you would like him to be considered for felony drug court, just let me know.
Yes, Judge, one further thing, I would have asked the judge, yourself, your honorable court, if you can consider the tap out of custody. He's been in custody for the last 5 months, Your Honor, and he's maintaining that he'll make all appointments and everything as scheduled. So I don't know what the tap is looking like, but if it's gonna take maybe like 3 weeks to a month, Your Honor.
Oh, it's not gonna take a month. My understanding is to take 2 weeks at the most.
2 weeks.
Yes,
Okay.
and I'll order a referral to felony drug court while in custody.
If it's looking like it's gonna be beyond that 2 weeks, can I reapproach the court? and see
Yes.
about- well, we can go from there? Okay,
All right,
thank you, Judge.
you're welcome. I'm gonna show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and also an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the deal. In this court, to be successful on probation, communication is key. If you have an issue, let probation know. If you feel as though they're not addressing it, we're always here in court except for holidays and weekends. All right, good luck to you. You're welcome.
Thank you, Your Honor. Be excused.
Yes.
Thank you, Judge.
Who is here on Layla Tanton?
And your,
Can I have a file stamp for a motion to revoke, please? Thank you. Hi.
hi. Can I ask a question about the story you were telling,
Which one?
about your work, when you were young and working? Did you have the confidence at the second job to say, no, I'm not doing this because of your Walmart experience?
Well, it's because, my mom empowers me, right?
Right,
And so she told me everything about unions and how you're supposed to have a break.
Right.
But at that time, this is my very first job.
right, yeah.
But then after that, I was just like, no, because I didn't want to disappoint my mom
Right,
by leaving that job. And then when my mom gave me the okay to leave that,
Howard,
and then we had a conversation and my mom said, baby, don't let anybody ever mistreat you and you can always come home.
that's awesome.
So
That's cool.
after that, it's like, all right then.
Yeah.
But you know what I would do? I would pick up the phone and call mom and I say like, Mom, this is what's happening. I still do that.
I do too.
All right, we're gonna call 2023 CR 3464, State of Texas versus Layla Ray Ann Tanton. Could I have parties announced for the record for the state
Jason Garahan, Your Honor.
defense?
Lauren Lepton, Stanton.
And are you Miss Tanton?
Yes, ma'am.
All right, and are we proceeding on the motion?
We
Yes, ma'am.
are, yes.
All right, Miss Tanton, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Layla Ray Ann Tanton who was placed on deferred adjudication for the offense of possession with intent to deliver a controlled substance, penalty group 1, 4 to 200 grams on October 2nd, 2023 and cause number 2023 CR 3464?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violated condition number 1, on or about the 11th day of March 2024 in Dare County, Texas. Defendant Layla Ray Ann Tanton committed the assault in violation condition number 1.
How do you plead to that, true or not true? True. All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor, and the state is taking into consideration cause number 729-646, which is the assault that she pled true to.
I'm sorry, 729
I'm sorry,
6.
729-646.
All right.
And we're taking that into consideration, but continue her on her deferred, so deny the motion and alter and amend for conditions of DDRF, followed by mixed supervision and wait for placement in jail, or amend for anger management. That's the recommendations by probation also, Your Honor.
All right, is that the proposed
That
agreement?
is, I would like to make the court aware of kind of the timeline of events that for today. So Ms. Tanton was originally in custody since August of 23 until her plea in October of 23.
Mhm.
That was where the court ordered she be evaluated for felony drug court originally.
Mhm.
So she had the felony drug court evaluation, was not accepting to that because of the mental health issues that she had been diagnosed with prior to even being in this court. Then it was recommended or suggested that she do SATF, I think, or SAFE. And then because of the mental health issues was told, no, that's not the right choice. And then in January of this year, she was evaluated for DDRF. There, for some reason February of this year was evaluated for January. And then the results came in February of this year. But for some reason, the ball kind of got dropped where even though she got approved for DDRF in February, she never got on the wait list to go get a vet at DDRF. So this assault did happen while in custody at the Bear County Jail. She has not really been given an opportunity. So we are in agreement that she go to DDRF, but given the kind of delay, she's not in line technically right now for DDRF. We would ask that the court expedite her in getting a vet at DDRF, given how long she's been a guest at Bear County.
All right, this is what the court will do. Court will deny the motion, alter and amend conditions to include the MIC evaluation and DDRF while in custody, anger management, and you to remain in custody until transfer. And then what I will do is, Norma, we're off the record. Can you give us a phantom date? And I have to do what's called a phantom date. Otherwise, if it shows that you have a court date in the system, what will end up happening, if they were gonna take you, they won't because you have a court date. So we'll be back here in 60 days just to see where she is on the list.
Your Honor, right now, the current wait time is anywhere from 3 to 13 weeks for DDRF. I just want to make the court aware that although we'll bring her back for a status update, they don't necessarily give us where they are on the list any longer.
All right,
So we
we'll-
can still bring her back, but
We're gonna bring you back. We're gonna find out something.
Okay.
Or I may come up with something else if it appears that it's gonna be too long.
I appreciate it.
Okay. I'm thinking. All right, Ms. Ferguson, 60 days.
And then the only other request, I don't know if we want to go back on the record, is I think in the original terms, she was going to reside in Medina, Texas. However, her mother, and it would be a better environment if she could move to Harris County, Baytown, Texas, upon completion of the DDR.
Well, let's
If I'm getting
approach that.
ahead of
No,
myself.
yeah, let's approach that after we figure out this. What date, Ms. Ferguson?
June 17th.
All right, so we'll be back on June 17th. And if you check at the jail, it's not gonna show up in the system, but we know that's the date and you'll be brought back. And this attorney will be here to make sure everything goes smoothly, okay?
Yes, ma'am.
All right, do you have any questions about anything?
No, ma'am.
All right, good luck to you.
Thank you.
You're
Thank
welcome.
you.
Just have a seat and pen.
All right, who's here on Diego Mascaro? Court is calling 2024 CR 1805, State of Texas versus Diego Mascaro. Could I have parties announced for the record for the state
Jason Garrett, Your Honor.
defense?
Sharon Thorne, the defendant.
And are you Mr. Mascaro?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Mascaro, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeding on count 1 alone. We're waiving count 2 and the habitual status.
Any objection?
No objection.
Mr. Mascaro, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
You understand you're charged with unlawfully carrying a weapon with a felony conviction? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered agreement will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, ma'am.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Mr. Massaro, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
No.
Oh, you're not satisfied with the way you've been represented? I'm sorry, what?
No, I'm not satisfied.
Are you not satisfied because you don't like the offer and you would rather go to trial as a habitual offender? I'm trying to figure out what's your dissatisfaction. Where is that?
My bad. I heard you wrong. Yes, I'm satisfied.
All right, so let's start again. Are you satisfied with the way Ms. Thorne has represented
ma'am.
you? All right. Are you a U.S. citizen?
Yes, ma'am.
Ms. Thorne, are there any issues?
No, Your Honor.
All right. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state is proceeding on count one. Punishment is to be assessed at 7 years in the prison. There are no applications. The state is taking in consideration NIMAG number 7496671, 7496669, county court cause number 7253577, 731-856. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to count one, how do you plead?
No contest.
State any evidence.
Yes, Your Honor. State exhibit number one with all its attachments.
Any
No
objection?
objection, Your Honor.
Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it?
Yes,
Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I ask that you follow the plea bargain that we have come to with the state.
All right, anything you wish to say, Mr. Mascaro?
No, ma'am.
All right, the court will sentence you to 7 years in the prison, give you credit for any time served. Taking consideration NIMAG number 7496671, 7496669, county court cause number 7253577, 731-856, and there's to be no contact with Leticia Molina Dela Cruz. Is there anything else with regards to sentencing?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Thank you, Your Honor.
All right, are we ready on Kent Wells?
Yes, you are.
Court is calling 2023 CR 9377, State of Texas versus Kent Richard Wells. Can I have parties announced for the record? For the state,
Andy, for the state of Texas.
defense,
Leo Gonzalez for Kent Wells.
are you Mr. Wells?
I am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Wells, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, I did. Yes, I did. Yes, I did.
Showing you true bill of indictment, did you review that with your attorney? Did you understand it?
Yes,
Counsel, do you waive the reading of the indictment?
I did, Your Honor.
State, are you proceeding on the indictment as presented?
You are, Your Honor.
Showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with failure to stop and render aid? The range of punishment for that offense is up to 1 year in the Bear County Jail and up to 5 years in the prison, and a fine not to exceed $5,000 or both the fine and the imprisonment and confinement. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand that if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you to the full range of punishment? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Your Honor.
Mr. Wells, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
They have not.
Anyone promised you anything other than the plea?
No.
Satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, there's a $500 fine and state recommends deferred adjudication. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State.
Yes, Judge.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, they have not.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be a TAP evaluation, 80 hours of community service restitution, and driver safety course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
State offered States Exhibit 1 and all attachments.
All right,
No
and you may
objection.
continue. Showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Did.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing the same, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We just asked that you follow the plea agreement, Your Honor.
All right, so are you employed?
Yes, ma'am.
What do you do?
Self-employed,
What does that mean?
environmental consultant.
All right, so in this stipulation, what was this about you taking photographs? All right, in the police report, they're saying that you told the guard at the gate to the subdivision that you were there to take photos for an insurance company.
For a brief period after COVID, I took on some part-time work,
Doing what?
taking photos of houses for insurance.
When the guard at the gate told you that you couldn't take photos of that home because the homeowner wasn't there, according to what I read, they called the homeowner, nobody picked up. Why didn't you just leave?
I did. I turned around and left.
No, that's not what it says in the police report. In the police report, it says that there were 2 cars behind you. And so the guard at the gate said, all right, this is what you can do. You come into the gate, you go around the island and come back, but you didn't. You kept going to the house where you said you were looking for, because then there's another witness who is with the homeowners association said, I'm gonna see where he went. That's what's in the police report, and that's what you stipulated to.
Right. It was 3 years ago. I just do not remember.
All right, I find it odd that people don't remember when they're alleged to have hit someone and run them over unless it's a frequent occurrence. All right, this is what we're gonna do. $500 fine probated, 3 years deferred adjudication. There's to be regular reporting by Zoom or in person. There's to be the driver's safety course. There's to be no contact with Michael Roger Hernandez. Or 55 Rogers Wood, located in San Antonio, Texas at 78248. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be 100 hours of community service restitution. The court will not allow that to be waived. There's to be anger management. Regular random UAs. Field visits. 1 time per month. For 4 months, then at the probation office discretion. Probation, is there anything else he needs? Is there anything else you need from the court? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you. You're welcome. All right, Dundre Scott. And then after that, we'll take up yours. All right, Ms. Ferguson, I need a reset date on Scott. Ms. Garza says she's ill. All right, are you employed?
Yes, ma'am.
What are your work hours?
I work 10 to 6:30,
What are your off days?
Wednesdays and Saturdays.
All right, well, we can't work around that. Let me see.
I have to just put a day in, and request it off.
All right, so this is what we're gonna do. He's not gonna be able to do it next Tuesday. He just missed work for today. So there's only so much work your employer will let you miss. So if we move this to the end of May, you'll have enough time to call your employer.
Yes, ma'am.
All right, Ms. Ferguson, give me the week of May 27th. I know the 27th is a holiday. All right, May 28th.
Yes.
All right, thank you for your patience. All right, are we ready on Adolfo Bustamante? Yes, sure. Adolfo.
Yeah, this is a waiver.
Okay. Court is calling 2024 CR 4817W, State of Texas versus Adolfo Kalanga Bustamante. Could I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Monica Guerrero for Mr. Colunga Bustamante.
All right, and we have an interpreter here. If you could raise your right hand for me, please. Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Carmen Tarragona Masais.
All right, and are you Mr. Bustamante?
Yes,
All right. Did you review the documents in Spanish with your attorney?
yes.
All right, and Ms. Guerrero, do you speak the Spanish language?
I do, Your Honor.
And were you able to review these documents with your client in Spanish?
Yes, Your Honor.
Mr. Bustamante, did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03? With your attorney, did you understand it?
Sí.
Yes,
Did you understand you have a right to have a grand jury, hear the evidence, and make a decision on whether or not to indict?
Sí.
yes,
Did you understand your right, your attorney has certain rights? Your attorney has 10 days to prepare for trial. And she has 2 days from the presentation of the information. Did you understand?
Mhm. Sí.
yes.
Did you understand by entering this plea, you were giving up those rights?
Sí.
Yes.
And did you intend to give up those rights and enter a plea?
Sí.
Yes,
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review the document entitled Application of Community Supervision with your attorney? Did you understand it?
Sí.
yes,
Counsel, have you received all the discovery and did you review that with your client?
Yes, Your Honor, on both.
Did you review the information with your attorney? Did you understand it?
Sí.
yes,
Counsel, do you waive the reading of the information?
I do, Your Honor.
Did you review the document with your, I'm sorry, state, are you proceeding on the information as presented?
Yes, Your Honor, we are.
Mr. Bustamante, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Sí.
yes,
Did you understand you're charged with continuous violence against family? That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Sí.
yes,
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Sí.
yes,
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent.
Sí.
yes,
Did you understand by entering this plea, you were giving up those rights?
Sí.
yes,
And did you intend to give up those rights and enter into a plea in this case?
Sí.
yes,
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Bustamante, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
no,
Has anyone promised you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
Sí.
yes,
Are you a U.S. citizen?
No.
no.
Counsel, has the defendant spoken to an immigration attorney?
I believe he has his own private attorney for that, and I have advised him of the potential consequences on a domestic violence plea.
All right, Mr. Bustamante, did you have ample opportunity to speak with an immigration attorney?
Sí.
Yes,
And did that attorney explain to you the impact a plea in this case of no contest or guilty would have on your immigration status?
No.
no,
¿No te explicaron eso?
No, es que el que está con el abogado es mi patrón.
Okay, pero no tenía su consejero, que es que sí te podía preparar esa inmigración.
Oh, sí.
oh, yes,
Sí.
All right, so did that attorney explain to you the immigration consequences of entering a plea of no contest or guilty in this offense?
Sí.
yes,
Did you understand that this is considered by immigration as a violent offense?
Sí.
yes,
And did you understand that The results of entering a plea in this case could result in your deportation,
Yes.
your denial of naturalization,
Yes.
and your ability to re-enter the United States. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney?
Yes.
Did you understand it?
Yes.
According to the plea, punishments be assessed at 3 years in the prison. State recommends community supervision. Take in consideration County Court Cause number 719221, Night Mag number 735-900. There's an affirmative finding of family violence. There's to be a TAP evaluation to follow those recommendations. No contact with Carla Judith Lozano Rojas. Did you understand with an affirmative finding of family violence, you're not allowed to possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes.
Did you understand that to be the plea?
Yes.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor, it is.
Did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right.
And then, Your Honor, of the 8 tapped files, if I may provide you a 9th tapped file in just about 3 minutes, Judge, and I will give you an additional element of State's Exhibit number 1.
All right, so this is what we're gonna have to do. I'm gonna have to have you all take a seat because there's a witness, a chemist that has to leave out of here by what time, State? All right, so I need to take this chemist up and then I'll come back to y'all. There's a missing document in that file. All right, so just have a seat.
Absolutely.
I have an appointment on the other side of town at 3:30.
Okay. All right, y'all need to,
I'm gonna get on her. I'm on it right now.
okay. All right, State, do you have your witness?
Judge, I believe so, I think Hank and Jason just went on.
Okay. Oh, were you able to print it?
Your Honor, it is still loading. We're racing.
I tell you what, if you can print it out, and Ms. Guerrero, would you be able to appear by Zoom? All right, so what we can do, if you'll print that out and we'll have Ms. Guerrero appear by Zoom. And Jason, are they ready with their witness on this case?
Yeah, Judge, they were just looking over something.
Okay, sure.
We could bring it.
Oh, who is here? Is there Jimmy Dotson?
He's sitting down, Judge. He's in the box.
All right, Mr. Dotson, if you come down, please. Who's his attorney?
Joe Stenberg.
Mr. Dotson, have you had any contact with your attorney?
They do, like around Christmas time, I spoke to him, but
All right, this is what we're gonna do. We're gonna recall you. And Norma, can you put this on April 29th or April 30? If you don't have any contact with your attorney, we'll do something else, okay?
Yes, ma'am.
All right, what date? All right, so we'll be back on April 30th and we'll make sure attorney is here. Sir, you can take a seat here if you're ready. Okay, you want to talk to the state about that and then I'll take this up.
Mind if I give this back to you right now, even if we do it another.
There's the report from
And
February.
Ms. Guerrero, did you have a chance to go over this report with him?
We reviewed the other reports from misdemeanor cases at the misdemeanor.
And that's the same one, Judge.
All right, so I'll be able to do you by Zoom. If you get the Zoom link from Ms. Ferguson, and then we'll call you back. This should be 15 minutes. All right. All right, we're back on the record in 2024 CR 0170, State of Texas versus John Stephen Meyer. I'm sorry, off the record. It was Daniel. Mhm. All right, we're back on the record. Could I have parties announced for the state?
Hank Wilkins and Daniel Escobar for the state.
Defense?
Baird and Mark Stevens for Mr. Meyer.
All right. And we're taking a witness out of order. Is that correct, State?
Yes, Your Honor, I've spoken to defense counsel. The forensic scientist has an appointment, so they don't have any objection to us calling the forensic scientist out of order, Your Honor.
All right. And who is your witness?
This is Mark Florence with the Bear County Crime Lab.
All right. If you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right. You can lower your hand, state your name for the record.
Mark Florence, Florence.
All right. And defense, are you stipulating to his credentials or no?
Yes, ma'am.
All right.
Thank you, Judge. Hi, Mr. Florence. So how long have you been at the Bear County Crime Lab?
29 years in June.
Can I approach the witness, Your Honor?
Yes.
Okay. And so did you do any what was your involvement in this case?
I did controlled substance analysis.
And what was your first interaction with the evidence in this case?
Oh, I received it from our evidence receiving section and in our building, and then I would have taken it to my laboratory and later on opened up the contents and testified it. And I'm sorry, analyzed it.
Okay, and did you what's the first step when you do drug testing in the case? You do a presumptive test? We'll have that. Okay. Yeah.
I usually will examine the contents. I'll open the envelope. I'll describe the contents. Then we'll weigh the substance by itself. And then we'll do a series of tests from general tests to more specific tests. These include color spot test, thin layer chromatography, and gas chromatograph mass spectrometry.
And what is the first test you did in this case? And you can look at your report or your discovery pamphlet. That's helpful.
Okay. The first test I did is a color test, a spot test.
Okay, and what was the result of that test?
It was a reagent known as a Marquise reagent, and it's clear substance. It does turn orange in the presence of amphetamines, and in this case, it turned orange.
And what does that indicate to you?
That it could be positive for methamphetamine.
Okay. And you've got some evidence up here. Can you tell us what's in this envelope?
Yes, this is an envelope which is marked with CIL 22-06464. has my initials on it, and inside is another container that has my initials on it and contains a sample of some evidence that was determined to be positive for methamphetamine.
Okay, and can you remove, you get take the contents out of that envelope, please?
This one here.
So, and what is that you have in your hand there?
This is item 1-1-1 of CIL 22-6464.
Did you perform any tests on that item?
Yes, I did.
And what were the results of those tests?
It was positive for methamphetamine.
And what kind of testing did you do on that?
I did the Marquise reagent spot test. I did the thin layer chromatography, and I did the gas chromatograph mass spectrometry.
For now, I'm just going to mark this as, I'm going to mark item 1-1-1 as States Exhibit P10.
What is it, 10?
I'm sorry, yes, sir, it's P10.
Thank you.
And then I'm going to mark, did you do a report reflecting your findings in this case?
Yes, I did.
And are you a custodian of records for the Bexar County Crime Lab?
Yes, I am.
Okay, I'm showing you what I've marked as States Exhibit P9. Can you tell us what that is?
This is a copy of the report I prepared for CIL 22-606464.
And did you come into any conclusions based on your analysis in this case?
Yes.
And what was that conclusion?
It had a net weight of 105.58 grams, and it was positive for methamphetamine.
Okay, so is it your testimony that item P10 is methamphetamine?
Yes.
Okay. And Your Honor, at this time, I offer State's Exhibit P9, which is the report.
No objections to P9.
No.
I'm sorry.
All right,
Some objection. We're not waiving our objections to anything seized from the home.
All right,
Okay.
and I'm
so
sorry.
No further objections to that.
All right, and I'm sorry, did you say the weight?
Yes, I did say the weight.
And what was the weight? I didn't hear
100
that.
105.58 grams.
All right, thank you. And P9 is it's states P9?
Yes, ma'am.
Right, states P9 is admitted over defense's objection.
And can you just briefly describe to the court the two tests that you did on the substance?
Okay, I did 3 tests. The first one I talked about earlier is the Marquise reagent test. I did thin layer chromatography, which is a separation identification technique that we use. We take, let's see, a substance and we compare it to an unknown substance. We compare it to a known standard. It's a wet chemistry technique. And also I did gas chromatograph mass spectrometry, which is an instrument we use which separates and identifies compounds by comparing them to known standards run in our laboratory.
So it's your opinion that that substance is methamphetamine, right?
Yes.
Okay. I pass the witness, Your Honor.
Defense?
Yeah. It's my understanding that you're in your lab one day and you get a sealed manila envelope. Is that right?
Yes.
Okay. And inside that sealed manila envelope is a Ziploc bag, right?
Yes.
And then that's item 1-1, correct?
Yes, that is true.
Okay. And then you create from that an item 1-1-1, which is a Ziploc bag containing a crystalline substance and another Ziploc bag containing another substance, correct?
Yes.
All right. And the first bag is what you tested, correct?
Yes.
Okay. And so the second bag you did not test.
I did not test.
Okay. And then
I'm sorry, you're referring to item like 1-1-2.
I haven't gotten there yet.
Okay,
And correct me if I'm wrong, but item 1-1 is a Ziploc bag,
yes,
right? And inside that Ziploc bag, am I correct that there were two smaller bags?
no, there was a loose crystalline let's see, I'm sorry, 1-1 was a Ziploc bag. 1-1-1 was a Ziploc bag, and it contained a loose crystalline substance. And it also contained a Ziploc bag containing a small amount of a beige clumpy substance.
So there are two Ziploc bags inside 1.1, correct?
Yes,
Okay. And of those two bags, you tested one of those bags, correct?
yes,
You did not test the smaller bag.
I did not.
Okay. And then also now going back to the manila envelope, there was another inside the manila envelope, there was one tape sealed manila envelope, correct?
Yes,
And you did not inventory that, correct?
that's true.
And does that mean you didn't even open that?
Yes,
Okay, so you don't know what was in it, right?
no, I do not.
Okay. And this is kind of a stupid question, but that's what lawyers are known for. Let me ask it anyway. So I take it you didn't test anything in that bag either, right?
I did not.
Okay. Anything else? Okay. Pass the witness, Judge.
No other questions, Your Honor.
All right, if y'all will make the exchange.
So Judge, the officer, Officer Perez, we're gonna put him back on the stand. Have him fill out the form, if that's okay.
Okay, yes, but if you can have him come in before he steps down.
Yes, ma'am.
All right, and is this witness excused or subject for recall?
Excuse.
All right, so if you'll just remain here till the officer comes to take custody of that.
Yes, Your Honor.
All right, thank you.
Your Honor, could I approach just to look at these?
Sure. And she's zooming in?
Yes.
So if you'll just, yeah.
And just give us 2 minutes to exchange things out.
Okay, yes, ma'am. Yeah, just- You got it. We don't need to sound. Yeah, leave it out. That's
All right. Cindy, you've been in on different cases, this case, that case. We're gonna finish him because the interpreter's here and his attorney is zooming in right now. So everyone, just give us a few moments. Sure. All right, so Mr. Bustamante. Adolfo Bustamante, if you'll have him come down. And Zach. All right, we're back on the record. In 2024, CR 4817W. Mr. Bustamante, your attorney is appearing by Zoom. Do you have any objections to your attorney appearing by Zoom?
No, it's fine.
All right. So where we left off, the defendant had entered a plea of no contest. Is that correct?
Yes.
State, do you have any evidence?
State offers State Exhibit 1 and all attachments, and for the record, this is dated last month.
All right. Any objections?
No, Your Honor.
Court has reviewed State's Exhibits 1 and attachments. Mr. Bustamante, did you review it with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, Ms. Guerrero, were you able to review that document with your client in Spanish and did he understand it?
Yes, Your Honor.
Mr. Bustamante, again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor. We would like to proceed with sentencing.
Anything you wish to say on behalf of your client?
Judge, he is very remorseful and he would like an opportunity to have this probation. He still does have an immigration hold, but like I informed the court earlier, he was working with an attorney that his boss got him for immigration purposes. So we're hopeful that he can get some treatment in this probation.
All right, and for the state? Zach Don?
Yes, Your Honor.
All right.
No, Daniel Escobar, who is?
Yeah.
No, we just absolutely agree and echo all the sentiments council made and no further comments from the state.
All right, have you had a contact with the complainant?
We have, Your Honor, yes.
And is the complainant aware of this?
Yes.
All right, the court will sentence you to 3 years, suspended and probated for 4 years. There's an affirmative finding of family violence. Excuse me, if you all could step off, you could talk in the corner. There should be a TAP evaluation in custody. Follow all recommendations. There should be no contact with Carla, Judith, Lozano, Rojas. There should be proof of employment within 45 days of release. There should be no employment as a home health care provider or with minors. There should be no illegal re-entry into the United States. Do you have any children?
Yes.
How many?
5.
What are their ages?
La más chiquita tiene 3 y el más grande tiene 2.
The youngest is 3 and the oldest is 12.
And are they with the complainant in this case?
Sí.
Yes.
All right, there should be the BIPP course. There should be no unsupervised contact with minors. 200 hours of community service restitution. Court is going to require parenting classes. Once he completes parenting classes, the community service hours will be deemed satisfied. There should be regular reporting by Zoom or in person, regular random UAs, field visits, 1 time per month until further notice. And there's to be no contact with Clara Lane. Thank you. And that is San Antonio, Texas, 78213. Probation, is there anything else that's needed? All right, I'm assuming there's nothing else needed. Is there anything else you need from the court?
No, it's fine. Thank you.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand?
Yes.
All right, probation, we'll go over conditions with you.
Your Honor, may I ask a question regarding the dismissals?
Yes, I've already signed those.
Okay, thank you, Judge.
You, all right, and you have one more client? Who is that?
Juan
I don't
Martinez
have paperwork
Pacheco?
on that.
Yes, Martinez Pacheco.
I don't have paperwork.
No, I don't know if he was gonna plead or
It's
what.
not a plea.
All right, could I have the file?
Judge, maybe I could ask clarification on that. I just sent an email to Monica with a new offer. I saw a note, indicating that that offer that I sent is.
Okay.
Yes.
Yes, you may be, well, just 1 second, because he needs an interpreter. All right, so what's the case is this?
I'm sorry?
What's the name of this case?
It's, Martinez Pacheco.
All right, on Pacheco. It's the court's understanding that, I guess, was there a counter offer?
So Judge, the defendant asked for another offer, while they were in court just a little while ago. I looked at the notes, I saw that we can make an offer that's similar to what they want. So I sent an email to them, to Monica, and I believe Joseph states it.
All right, so, Ms. Guerrero, are you able to come back on Thursday?
Judge, I have a vacation notice on file from Thursday, the 18th to April 28th. I will be out of the country. I can have Mr. Stateson appear, but he does not speak Spanish. My concern on the offer was that they were basing it on a criminal history from a guy with a similar name and similar date of birth. That's a US citizen, and my client is not a US citizen. So it's my belief that these fingerprints don't match my client and that that is not his criminal history because he is not a US citizen and he's only been in Texas.
And Judge, I'll add further clarification. I did ask for our investigator to run the NCIC again. Nothing came up for this individual, so then whenever I made the new offer, plus a note that I called about.
All right, so he says that it's not there. That the fingerprints came back and it's not the fingerprints to your client.
Okay.
All right, so if you all want to come back on the 17th, we can come back on the 17th.
Tomorrow?
Yes, but it'd have to be in the afternoon.
Okay, let me see if I can have somebody cover my juvenile case in the afternoon.
All right, so you want to say? What would it have? Okay, what time? Okay, 3 o'clock.
Okay.
And if you speak with him and he decides he wants Mr. Stateson to do it, we can bring him back on Thursday.
Okay, well, let's see what a plea offer is. And
All
then
right.
I can let you know for sure tomorrow.
All right, thank you.
Thank you, Your Honor. May I be excused?
Yes,
Thank you.
thank you.
My pleasure, Your Honor.
Your Honor, just a quick side note, I wanted to confirm with you that whereas we've had contact with the complainant in the past, I've personally reached out to her and we have not been able to get on.
Okay.
So that is the most up-to-date side. So in terms of attempted contacts and reaching out to her multiple times, that is absolutely there, but we have been a lot successful.
Okay. All right, we're back on the record in 2024 CR 0170. State, you're recalling your witness?
Yes, Your Honor, state calls Deputy Perez.
All right.
Your
So
Honor.
we're supposed to have, the court will hear argument with regards to whether or not the statement that's alleged to have been made by the defendant is admissible. So the court will hear argument. The court will hear brief argument.
Do we hear that outside the presence of the witness, Your Honor?
All right, if you will step outside
Yes,
just
ma'am.
briefly. And if you could take the items with
Yes,
you.
ma'am.
All right, thank you. And if you want to just step outside to the back door out there instead of out here, you're more than welcome to do so.
Appreciate it.
Thank you. All right, the court will hear argument. Defense.
Your Honor, at least three things are, I think, uncontroverted. It's custodial interrogation. And the statement was not electronically recorded. So what we know also is that because Mr. Pettis testified that first the lead detective Rios talked to Mr. Meyer, and he said nothing. Sounds like a invocation of his constitutional right to silence. So then, after that happened, Pettis admitted that he said, "I thought I'd take a crack at it." He gave him some kind of warning, but we don't know what. All we know is the only thing this investigator Pettis could remember is that he emphasized that Mr. Meyer had a right to stop talking. Well, I think there's authority for the proposition that there has to be substantial compliance with Article 38, and that's not substantial compliance. So that's reason number one. We would say that under Article 38.22, Section 3A1, this custodial interrogation statement was not electronically recorded. Number two, Your Honor, second independent reason, and I just said that there's no evidence that he gave a warning that anywhere near complied with the warning required by Miranda v. Arizona and its progeny and the Fifth Amendment to the United States Constitution made applicable by the 14th. And also, Your Honor, Article 38.22, Section 3A, read in conjunction with Section 2A, says that it specifically prescribes the warnings that are required. Again, no indication that those were given. So that's an additional reason to suppress, Your Honor. No compliance with either Miranda or 38.22, Section 3A. Three, Your Honor, no compliance with Article 38.22, Section 3A2, which requires not only the warnings, but after the warnings are given, a knowing, intentional, and voluntary waiver. Nothing like that happened. Pettis testified he wanted to take a crack at it after Mr. Meyer asserted a right to silence. And then he gave him insubstantial warnings and told him that we're going to stay here until you tell us where it is. And only after that, according to Pettis, and we don't have a recording of it, of course. So we don't think that constitutes the knowing, intentional, and voluntary waiver required by the Texas statute. Additionally, Your Honor, we've got a voluntariness problem. Under the 5th and 14th Amendments of the United States Constitution, both the 5th Amendment and the 14th Amendment due process of voluntariness. It's not voluntary at all when you invoke your right to silence. An officer has to work on you for 5 minutes after giving an insubstantial Miranda warning, and then tells him, we're going to stay here until you tell us where it is. So constitutionally, this is an involuntary oral statement. The next number, Your Honor, is 38.22, Section 3A1. I've already said that. That's not electronically recorded. The final argument, Your Honor, is Mr. Wilkins indicated he thought the exception applied to this. It does not. First of all, that exception would never trump the United States Constitution, Miranda v. Arizona, and the 5th Amendment. It would never make voluntary an involuntary statement.
Okay, so just a second. Let me have everybody time out. And let me just tell you, what my ruling is. With regards to whether or not it's recorded, that argument will be overruled. My focus is the Miranda and the fact that the witness said that he Mirandized the defendant. But what does that mean? The only thing the witness said was he Mirandized him and he focused on his right to terminate. And I think both parties are aware what Miranda says, and merely telling someone that you have a right to terminate the interview at any time is not Mirandizing someone. So that's where we are. And if I heard incorrectly, someone let me know. But what I recall the witness testifying to is he Mirandized him. And then he said, I have a card that I read or something that's on my clipboard that I read. And I know that I focused on his right to terminate the interview at any time. That's what the court has before it. So state, that's what I need to focus on. And the question really becomes whether or not his testimony equals he Mirandized him, because the state you stipulated that he was in custody when he made this statement. So that's where we are with regards to whether or not this should be suppressed.
Yes, ma'am. So I think the testimony that Deputy Perez gave, where he says, I Mirandized him, I Mirandized the defendant. He doesn't have the Miranda warning memorized. He reads it off of something on his clipboard. I know that I think that's probably a best practice, Judge, to not rely on just your memory, to go back to the clipboard. So Your Honor, I think the testimony that he gave the Miranda warning, and that in response to that, the defendant made this statement is, I think that I agree with your reading of this, Judge.
All right, so with regards to the suppression of the statement, that's going to be granted. All right, you can call your witness back. All right, you're still under oath?
Yes, ma'am.
All right, state.
So after you spoke to the defendant, what is the term y'all use for the person who catalogs the evidence? You're not on the.
I'm sorry, I can't hear you.
So what is
the
the
machine's going?
Sorry. What is the term for you're the evidence custodian? Is that as part of the search? What is it?
Right, we call it evidence tech.
And so you're not going around finding everything, but you're the one who takes everything into custody?
Yes, sir.
And so did you find any narcotics as part of your search of the house?
No, so I did in the, what I saw in plain view, you see remnants of what I believe to be methamphetamine.
Judge, I'm going to object. He's not competent to testify of what he believes to be. If it's a chemical like that, it has to be tested. He can't, an officer is not competent to give his opinion about what a substance is other than marijuana, and this is not marijuana.
All right, so that'll be overruled. He can answer the question.
So can you tell us some of the?
Yeah, due to my training, my experience of 6.5 years that I believe to be alleged methamphetamine.
Can I approach the witness, Your Honor?
Yes.
So this is State's Exhibit P10. Do you know where this was found?
Yes, sir, I do. That was an event kind of between hallway leading into the main living room.
Okay. And did you collect? You're the evidence tech, but you didn't find this in the event, right?
No, sir, I did not.
And then can I see those photos?
Yeah.
So I've got Exhibit P2, State's Exhibit P2. Can you tell us what's in this photo here?
Yes, sir. This was in the master bedroom. I'm looking at, I believe one was a loaded syringe of heroin, and one was just, residue of, also alleged, heroin.
Judge, we're gonna, again, same objection. He can't testify that a substance is heroin. He's not a chemist, so he's not competent and qualified to do that.
Okay, so you're stating that you believe that's what it is, correct?
Yes, ma'am.
All right, so that'll be overruled. My understanding is the chemist has already testified to what the items are. Am I incorrect on that?
Chemist identified only the large packet, P1 maybe. I'm not sure how Hank.
Yeah, so Judge, this has been identified as methamphetamine, Judge. The crime lab didn't test the syringes. So this would just be the officer's opinion on what's in the syringes.
Well, that'll be sustained.
But
I'm so sorry.
I was gonna ask.
Yeah, the crime lab also, he said the chemist didn't test anything other than that large packet, and there were two other Ziploc baggies that he didn't test inside there, so.
All right, that'll be sustained.
So can you tell me what room of the house this was? And if you need to look at your reports, that's okay.
No, sir, no, exactly where it was, master bedroom, restroom.
Okay. And so how does it work with one of these searches if you're the evidence tech? Sorry, let me get back to the microphone here. So other officers have found these items and then they flag you down and say, hey, you need to collect this.
Yes, sir.
And so were there other narcotics or suspected narcotics that y'all collected at the time?
Yes, sir.
Did you find any suspected narcotics in the den area?
Judge, again,
Yes, we did.
Again,
All right, that'll be sustained. So here's the court's ruling so everybody can understand it. Whatever he saw in the house, if he wanted, we're off the record, whatever he saw in the house, if there wants to be a photograph of it and somebody's saying, this is a photograph or what I took, fine. But as far as his testifying what he believed it to be, or if he did some sort of presumptive test, that's all inadmissible. Okay. All right, we're back on the record.
Did you collect any evidence from the den area of the house?
Yes, sir, we did.
Okay. Did you collect any firearms from that area?
Yes, sir.
And do you have your non-narcotic evidence report in front of you?
No, sir, I have I got 2 narcotic evidence reports right in front of me.
Yes.
Did you collect any scales as part of your search?
Yes, sir, we did.
Can you tell us where you found those?
I do believe right off the top of my head, I know for sure we found one in the master bedroom restroom. And I'd have to review, I think we found some also in the den area with the firearms.
And so were those all in the den or were they in other places?
From what I recall, I believe for sure I can tell you the rifles were.
you know, could I have clarification? We talked about located versus recovered or collected. Are we talking now about him when he saw them after somebody else had located them?
All right, counsel, you'll have a chance to take the witness on cross-examination. You may continue.
And so what kind of firearms did y'all recover from the house?
I know for sure the 3 rifles, 2 that I believe to be M4 assault type rifles, 1 hunting rifle, and 2 semi-auto pistols.
One moment, Judge, sorry. Did you find anything in the barrel of any of the guns?
Yes, sir, we did.
Okay, and you collected that evidence?
Yes, sir.
And so once you collect something like that, do you send that off to the crime lab?
Yes, we do.
But the only item that was tested is that, the big item that was found in the vent, right?
Yes, correct, sir.
I pass the witness, Your Honor.
Right, defense?
So, Mr. Pettis, just to be clear, may I approach, Your Honor?
Yes, and both parties feel free to move about the courtroom.
Y'all don't have the Elmo's here.
No, we don't have it plugged in.
That's okay. Your Honor, rather than plug the Elmo in, if I could just show the court what I'm talking about when.
Sure.
Sir, I'm going to show you State's Exhibit P1. You're familiar with that?
Yes, sir.
Did you take that picture?
Yes, sir, I did.
And you said that was at the Bear County Sheriff's Office property room, is that right?
Yes, sir.
Okay, so somebody put these items, there's rifles and there's other things. Sorry, Judge.
Oh, that's okay. I'll step down so
Okay.
that I can see. And State, if you want to move about.
Somebody, did you place all these items on the table in the Sheriff's Office property room?
Yes, sir, I did.
Okay. So I'm gonna just point to an item on P1. It looks like a Ziploc baggie with some white crystalline material in it, right?
Yes, sir.
And I'm also gonna point now to P10. So is the item I'm pointing to on P1, that Ziploc baggie, a picture of this P10, the substance introduced and identified as methamphetamine?
Yes, sir, it is.
Okay. Now, you did not see this item recovered, did you?
No, sir.
Now, so we've talked about the terminology. You admitted that you did not locate the items. Somebody else located each of the items and then put them in, where do they put them? In the den area?
Yes, sir.
Okay. And then you recovered them from there.
Yes.
So you have no personal knowledge, or do you, where any of these items on P1 were actually located by the deputy who located them?
I did have knowledge, sir. Mr. Meyer informed me what the narcotics were.
I said, you know, I'm going to object to that. That, first of all, it's non-responsive. And secondly, it violated an order of the court.
He didn't know about the order of the court though, Judge. I mean, I just didn't ask him about that, but I didn't tell him, hey, don't mention that. So that's my fault.
Oh, no problem. So for the record, and the record will be clear, the witness did not know of the court's ruling. So that your objection will be sustained.
And I moved to strike that from the record, Your Honor.
All right, well, the record is going to show what it shows.
I'll ask the court to disregard it then as a finder of fact.
Yes, it's disregarded.
Okay. So what I'm talking about is personal knowledge based on what you saw that day. Did you see any of these items located in the position they were located in by the deputy?
I did observe Deputy Wolf going up a ladder and pulling an item from the vent in the hallway.
Were you in the room at that time?
Approximately about 15 feet away from where Deputy Wolf was. I was probably near the front door.
So you know then that this item that was taken from the vent was in a black pouch, do you not?
Correct. I saw something black in color.
And so to be clear, State's Exhibit P10, the substance identified as methamphetamine was inside a black pouch and then up in the ceiling. Is that right?
Correct.
Okay. And there were 4 cell phones found in the black pouch with this P10 methamphetamine. Is that right?
That I could not tell you, sir.
You were
I
there,
didn't-
you don't remember?
I didn't see it was pulled out of the bag.
Okay. May I show these two?
Yes.
These are all from the, just the body cams. That would be, Juan's body, all of the Juan's body cams, I think, with the dog man. And these, were subsequently taken, just to show how tall that is.
Okay,
I'll see if he knows, you know,
so these are from the body cam.
these are pictures taken.
So the all these are.
Gotcha. This is to show it's 10-foot ceiling. And I probably won't ask him that, I'm gonna ask him before. You talk about Detective Wolf going up to a vent. Let me just show you. Defendants exhibit P20, P21, P22. Does that look like Detective Wolf in that picture?
Yes, sir. As far as I can tell, yes, sir.
And is that the way you remember the scene, him climbing up on the ladder to get into the vent?
Yes, sir.
And we see him in sort of sequentially, but in P-22, he's actually up on top of the ladder, reaching into the vent.
Correct.
Okay. Now I'm going to ask him some more questions. May I ask, will Wolf testify?
Yes, sir.
Okay. So I'll ask him some of these questions. Do you recognize Defendant's Exhibit P-19?
The persons?
The persons, yes.
Yes, sir.
So is Detective Wolf shown there? Investigator Wolf?
Yes, sir.
All right. And he is handing a gentleman, who is that? Is that Mr. Rios?
Yes, sir.
Okay, so Defendant's Exhibit P-19 shows Mr. Wolf handing Mr. Rios what looks like a cell phone.
Just from that picture, sir, I can 100% tell you
Okay.
this.
Were you there?
I was there, but that's not my body cam. I wasn't facing the office.
Right. So you know that Wolf borrowed Mr. Rios' cell phone to use the light function on it, to flashlight function on, don't you? You were there.
I don't recall, sir.
Okay. You can't see it in this picture. By the way, this picture P-19 comes from, it's just a still snapshot from the body cam. You can see the body cam.
Yes, sir. I see.
And you can see the time on that would be, it's recorded as 1756. What's time in English language?
That's 5:56 p.m.
Do you know or not whether the clocks were on the body cam were working correctly? Does that sound like about the right time?
Again, sir, I'm going to assume they were.
Okay. Your Honor, may I show these photographs to the court?
Yes, please. Are these already admitted?
Offer them, Your Honor.
All right, so defense, state.
Yes, all those are body cams.
No objection, Your Honor.
All right, then, defense is P-19, P-20, P-21, and P-22 is admitted without objection.
Sir, you'll admit then this P-10 was not in plain view.
No, it was not.
I mean, that's correct. Is that right?
Yes, sir. We couldn't find it.
All right. Each of these, I'm looking at P1 right now. Each of these rifles and they're two pistols. Nothing illegal about those weapons, is there?
None that I see.
Okay. Now, you said these were in the den when you saw them. You don't know where they came from, do you?
No, sir.
Do you know which officers found them?
It should be in their supplements, so I couldn't tell you about it.
Okay. If we look at, now, tell me about P4. That's another photograph. Did you take that photograph?
Yes, sir.
Okay, and that was that's in the den area, is it not?
Yes, sir.
So we see some of the same rifles on P1, which you took downtown, that are also laid out on P4 in the den area, right?
Yes, sir.
But you don't know if these were found there or not. In fact, you probably know they weren't found there by whomever it was that located the handguns and the rifles. Is that right?
That's correct.
Okay. So you don't know where they were found.
That's correct.
And this looks like P7 looks like that same table that's in P4 before these items were on it. Would that be true?
Yes, sir, that's correct.
Okay. How many cell phones does your non-narcotics evidence report say were seized?
I have 4 cell phones, sir.
I see only 2 in P1, which is all the evidence laid out by you at the property room. Where are the other 2 cell phones?
I couldn't tell you right now, sir.
Okay. Where's the black pouch that P10 was found in?
Again, I'm just gonna assume that got left and that narcotics was taken.
Okay. The cell phones, were there 4 or were there just 2? Do you know?
I have 4 in my narcotic evidence for whatever reason. I don't know why there's only 2 in there.
Okay. And they were found in the black pouch with methamphetamine by Wolf.
Yeah, I look at it before.
Okay. Well, I'll ask him. You don't remember?
No, sir, no.
You were standing there?
It was in 2022, sir. I don't recall.
Were any of these phones, were extractions done on any of these cell phones?
That wouldn't be shot to be so.
You were the evidence tech. Who would you?
Collect the evidence. He sent that off for a phone dump.
Okay, so you did collect the evidence, but you chose not to send it off for a phone dump.
That wasn't my job to do so.
Whose job was it?
That would be the case agent if you decided to pursue.
Who was that? Rios?
That would be Rios.
And if we don't have any evidence of a phone dump, we have to assume none was made
We'd have to assume.
on any of the 4 phones
Yes, sir, that's correct.
that were found in the same black pouch as this methamphetamine.
Correct.
Any fingerprints taken off this pouch?
No.
Okay. Any DNA taken off the cell phones, this pouch,
No, sir.
the black pouch,
No.
fingerprints off any of these items at all on
No.
P1?
No, sir. Not to my knowledge.
P3 is the you recognize that purple blanket?
No, not all.
Okay. But you got a handgun. Where was that? Did you take this picture?
Yes, sir. It possibly might be his bedroom. Yeah, I can't tell you about it.
Well, might be somebody's bedroom, right?
Correct.
Okay. Do you know the name Theda Reyes?
Yes, I do, sir.
Do you know that, you know where she was arrested that day?
No, I wasn't on the entry team, sir. I don't know where she was taken now.
Connor, may we pull up a video just to show?
Yes.
Oh, here I go. Sir, you know Fernando Luna, do you not?
Yes, sir. I
Who is
do.
Deputy Luna?
Deputy Luna is assigned to our covert intel team.
Was he on the entry team that day?
Honestly, sir, I cannot tell you that.
Okay. You think you'd recognize his voice?
Yes, sir.
Okay. So what time is that on that body cam?
24 hours. It's 4:24 p.m.
Okay. So that's sometime before you, if you're, the pictures I showed that you took would be taken around, do they have a time on the pictures, by the way?
They don't, sir, but I think that one, that previous with Wolf, I think we said 1756. I would probably give 1700 time frame.
Okay.
1730. Give or
Okay.
take.
Okay. 1730 being 5:30 or?
Yes, sir.
Okay. All right. Would you play it, Mr. Escalon?
Give me a body in the back row.
Okay, so we pause it, please. He says, give me a body in the back room, right?
Yes, sir, he does.
What's code for give me a body? What's he asking for?
I need another deputy.
Okay.
All right, so here's, just one second, here's my question. What is the exhibit number on this?
I didn't put his exhibit number on it today.
All right, is this being offered into evidence?
I would like to offer it to see if it refreshes this officer's recollection.
All right, so.
I'm sorry, Jim.
No. So if y'all are offering it to refresh his memory, then I shouldn't be seeing it because a jury would not be seeing it. So if y'all want to offer it to refresh his memory, I'll step out of the room and let y'all have him review it. And then y'all can come back with questions. And if y'all want to offer it, then you can offer it.
Could I try to offer it without refreshing? Because he may not,
Well, so it can be done appropriately. Let me just step out and you all play that for him. And if it refreshes his memory, it refreshes his memory. If it doesn't, let me know. If y'all want to offer it into evidence, let me know. So I'll step out. How long is the video?
Judge, I don't want to play the whole video. This portion lasts about a minute.
All right, so I'll step out and y'all can have the witness review that and see if it refreshes his memory.
Okay.
All right, so just give me one moment, please. And then Ms. Abrams, if I could see you, please. Yes, I'm gonna go talk to them about this right now. If I just respond.
Sir, would it be fair to say that we saw outside judge's presence, we saw Deputy Luna getting Theta Reyes out of bed in the bedroom, in the back bedroom where he asked for more bodies?
Yes, sir.
Okay. And that time was, what did we say, around 5:30?
I would go 5:30-ish. Yes, sir.
Okay. Yeah. And we know because we saw a purple bedspread in the video and on P3, State's Exhibit P3.
That is correct.
But when for the judge's benefit, you testified that the items on the bed, you don't know when they got put there. You assume it was the deputy, whomever that was, that found those items.
Correct, sir.
Okay. So that explains P3. Yeah, have just a minute, Your Honor.
Yes.
Did you, sir, ask for a blood draw or ask that a blood draw be taken from John Meyer?
No, sir.
Did you ask that one be taken from Theta Reyes?
No, sir.
Did you look for needle marks on John Meyer's arms?
No, sir, I did not.
P28, I think, right? Investigator Pettis, I show you defendant's exhibit P28. Did you take that picture?
Yes, sir.
Is that a person you know to be Theta Reyes?
Yes, sir.
And she was in the house that night when the deputies entered?
Yes, sir.
And that was her getting out of bed in the back bedroom in the video we just saw, was it not?
Yes, sir, it was.
Offer defendant's exhibit P28, Your Honor. No
Any
objection.
objection?
No
All right,
objection.
defense exhibit P28 is admitted without objection.
No cash was recovered on November 1st from 224 Majestic Grove, was it?
I'm sorry, was that the first warrant?
That's the warrant on November 1st, would be, that's the warrant I'm asking about.
Not that I recall.
Well, could you look and see? You being the evidence technician would know that, wouldn't
No,
you?
I'm looking down.
Okay.
No, sir.
John Meyer was searched, was he not, that day?
I would assume so.
your records don't reflect that he was found in personal possession, any drugs or paraphernalia were found on his person, do they?
No, not my records.
Now approach, Your Honor.
Yes.
Sir, I'm showing you defendant's exhibit P17. Did you see those two vehicles on November 1st, 2022 at the residence 224 Majestic Grove?
Seeing the pictures and the date they were there, honestly, I just don't recall.
Sure. And we can see the date they were there and the time that body cam was taken.
Yes, I see it.
Okay. You just don't know who those cars belong to?
No, I do know Miss Reyes did drive a white car, but I see two white. I couldn't tell you which one she was actually in.
Fair enough. Mr. Pettis, you were inside the residence, were you not?
Yes, sir.
And you saw a large number of tools, did you not?
Yes, sir.
It was obvious that there was construction going on in the house, was there not?
You know, some kind of renovations from what I recall, but I can't remember that entire house.
Sure. That's all I have.
All right, state.
No further questions, Your Honor?
All right, is this witness excused or subject for recall?
Excuse from the state.
Could we just,
I think we're meeting, but
Yeah.
just making available.
if he could be available, Jim?
All right, the rule has been invoked. Make sure you don't discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state of the defense. And you may step down, and if you want to do the exchange with the court reporter
Yes,
in
ma'am.
regards to the exhibit.
Yes, ma'am.
All right, thank you so
ma'am.
much, and thank you for your patience.
Yes, ma'am.
Judge, should we take 2 minutes?
Yes.
Okay. Yeah, we have a property receipt form. But I think he's gonna get the actual deputy that made the request for discovery. He's gonna get it right now. We do have a form. So, yeah, that's actually a first for me as well. I know.
Oh, and Sydney, here's the exhibits.
And you took some testimony outside your presence, and I've never done that, so.
Oh,
I just
yeah,
made
no.
sure to put it on the record, because
Oh, no, they probably did. I don't know if they did a bill or review of what they were doing. Yes. So they may have done it as a bill or review.
Yeah, they discussed that.
All right, state, call your next witness.
State calls Deputy Brian Wolf, Your Honor.
All right, could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Brian Wolf.
Deputy Wolf, how long have you been with BCSO?
We're going on about 30 years.
And are you a licensed peace officer?
Yes, sir.
And did you assist in serving a search warrant on 224 Majestic Grove on November 1st, 2022?
Yes.
What were your duties as part of that search warrant?
I mainly assisted with searching.
Okay, and can I approach the witness, Your Honor?
Yes.
Oh, did you find anything when you were searching?
Yes, I did.
Okay, did you recover what I've previously marked as State's Exhibit P10?
Yes, I did.
Where did you recover this?
It was in an air conditioning duct in the front entryway up high.
You personally recovered this?
Yes.
Okay. Your Honor, I offer State's Exhibit P10.
Any objection?
Same objections, Your Honor.
All right, that'll be overruled. P10 is admitted.
And then, what do you do once you collect something like this?
Once I recovered it from the air conditioning vent, I gave it to Deputy Pettis.
Okay. And what's the standard procedure once something like that is collected?
Generally, the evidence technician will go ahead and mark it, who found it, where it was located, and they'll package it appropriately.
And where all did you search in the house besides the air vent up there?
Mainly assisted in that front room. There's a large room in the front there in the hallway. And I was concentrating there.
Did you find anything else?
No, I did not.
Did you, how'd you know to search in the vent?
Objection, Your Honor. Sure, sir.
All right, that'll be overruled. You can answer.
Deputy Pettis.
Also, Your Honor, it denies us our right to confront and cross-examine under the 14th Amendment to the United States Constitution.
All right, you can answer the question.
Deputy Pettis advised me to look in the vents.
Okay. Anything else from this guy? Your Honor, can I approach?
Yes.
Could you tell me what this number is here, this one?
What is it? 22-06404.
Yeah, let me look. That last number could that be a 6? The second to last number, I'm sorry.
Oh yeah, it could. It's very faint on top.
Are those markings that you make, or is that something that the crime lab does?
This one was probably the crime lab because we don't package in these bags.
Okay. So once you found it, you told Pettis, because he's the evidence tech, to collect it?
Yes, I actually, if I remember right, handed it down to him because I was on a ladder.
Oh, okay, so you're on top of a ladder, you hand it down.
Yes.
I pass the witness, Your Honor.
All right, defense.
Investigator Wolf, I have one supplemental incident report from you. Is that the only thing you wrote about this case?
Yes, sir.
And P10, that I think the drugs are P10, is that right?
Yes, that's what they're labeled as.
Okay. You didn't seize it just like that, did you? it was inside a black bag.
Correct. It was inside a zippered bag.
I'm sorry?
A zippered bag, like a bank bag.
Okay, a black zipper bank bag,
Yes, sir.
and that was zip closed?
Yes,
And also inside that same black bag were cell phones?
yes, sir.
4?
3 or 4, I don't recall exactly. I have to look back in my report.
What did you do with the 3 or 4 cell phones that were in the black zipper bag with the methamphetamine?
As I stated before, I handed it down to Deputy Pettis.
And you don't know what he did with them?
No, sir.
Okay. Fair to say that the P10 was not in plain view, as you understand that term in law enforcement.
Correct.
In fact, you even would you agree that that was a 10-foot ceiling?
I had to use a ladder to get to it, so it's probably a 10-foot ceiling.
Okay. Do you see, may I approach you on?
Yes.
Your Honor, could I look at those photos that were introduced?
The court reporter has those.
These have already been introduced into evidence, but you probably recognize that guy?
Yes,
That's you?
yes.
And I'm showing you P20, 222. Read it, please.
P22, yes.
Defendant's exhibit P22 is a photograph of you up on top of the ladder, reaching into the vent.
Yes.
Okay. And do you remember do you remember making a comment? By the way, you asked to see, was it Rios's phone so you could use the flashlight function on it?
I used someone's phone, yes.
Okay.
Remember.
And you remember feeling around a minute?
I remember just feeling inside left and right, and then the bag was right there.
And do you remember saying, I think I'm quoting you, this is hidden pretty fucking good.
I don't recall saying that, no.
Okay. Could we play that clip real quick?
Is this, you want to refresh it?
Well, I don't think he was there. I mean,
Well, I mean, are you all offering that into
I'll
evidence?
offer it, Judge. It's a clip. It's about a minute long.
Well, what are you all offering though? Y'all want to
Well,
lay the foundation or
I can-
state? Do you have any objections?
I think we got to do the refresh the memory thing again, Judge, because he doesn't have it on a disk or anything. It's on the.
All right, so I'll step outside and you all can refresh his memory. Ms. Abrams, could I see you, please?
Wolf on the line.
The shot.
Right.
And guitar, you're good.
You already got this?
Yep.
Should I just click on this? And you better do it.
Yeah, I got you.
We're going to show you a brief, about a minute or two clip.
Sorry, I'm just waiting for Judge to. Go to close.
You see that?
Yes.
Sorry.
That's fine, Mr. Epstein. Does that refresh your memory, investigator?
Yes, sir.
Okay. Were you able to hear it okay?
Yes.
I'm ready for the judge to tell
She's in the hallway. Ready?
You were out. She asked if she could see those letters.
Oh, yeah. Yeah. I love that.
We'll let you know that she was.
Oh.
All right, is everyone ready?
Yes, ma'am.
Your Honor.
All right, defense, you may continue.
Judge, I haven't marked this exhibit yet. I can put it on it's just about a minute long or so.
Are you going to be offering that into
I am
evidence?
gonna offer to.
All right, and what is it going to be marked as, and is there going to be any objection?
Well,
P 29, Your Honor.
I don't necessarily have an objection, Judge, but we gotta have something to put it on so it can be entered, I think.
Yes.
I'll bring a thumb drive if I can, as quick as I can.
Well, is there a disc or anything to put it on? A blank disc, maybe?
I might have a blank disc. You got a blank?
So are you gonna put, so this is just that one, the body cam? Or, yeah, body cam.
And state, I know yesterday you all said you had no objection to the court reading the character letters.
Yes, ma'am. No.
So I've already read those in case you need them back.
I was gonna offer them and make them part of the record,
Okay,
but I'll do that. It's our turn.
all right, so I'll give them back to you so you can have that, Mr. Barrett.
Sleeve.
Yes, I read it and I put it back in the sleeve.
You're a fast reader.
Yes, I love reading. I think I may have been the only person in elementary school who read, what was the name of the book? A Tale of Two Cities. I found it very,
Best of times. It
was worst of time. Hey, there was a queen with a square jaw.
What?
There was a queen with a square jaw. You know, that's part of that, sitting on the throne here.
Yeah.
All right, so is it able to transfer?
Yes, ma'am.
Judge.
Okay.
The whole body cam or just a portion of it?
It's just a small portion of it. When you kill them, like, once it gets on again, it shouldn't be more than 2 minutes long.
Oh, yeah, no, once this runs out.
Quick burn in there though.
No, it's already on there. Just once this all completes.
Avon's not good. Which sticks are gonna put to Jack after he brings something onto it.
I'm glad you know all this stuff. We ready?
It's almost done.
Oh,
It just
okay.
needs to come out.
Okay.
Going to- Close it off for signs. If I close it out, I don't know what's gonna take place.
Just ask him to refresh his memory. We can do that. Well, let me try it that way, Judge.
Okay, sure.
We need the exhibit. Detective, you saw the video clip, did you not?
Yes, sir.
And that came from a body cam of one of the other deputies, right?
Yes, sir.
And it was done on November the 1st, 2022, when you assisted with the search warrant.
I'd have to look back to the exact date.
Do you have a copy of your report with you?
I have a copy of the. Yeah.
November 1st.
2022.
Okay. Now, you remember that there was a bunch of tools and construction items at the scene on November 1st, was there not?
Yes.
And in fact, the ladder you used to climb up to the vent was a ladder at the scene, wasn't it?
It was right there by the vent.
Right, so it was in the residence.
Yes.
And do you recall how tall that ceiling was?
No, I don't recall the exact height. When I stood on the top of the ladder, I could reach in the vent.
Okay.
So
If may I approach you?
Yes.
I'm just going to show you these. If you recognize them or not. And I'm going to show you what. I'm going to show you what's been marked as Defendant's Exhibit P 29. Does that, you recognize that scene?
it does not look the same. It looks to be the same house, but it's cleaned up.
Cleaned up, but the same house it looks like, right?
It looks like the same house.
Can you see the vent perhaps in that in the hallway?
Yes.
So apart from it being, the house being cleaner and a lot of construction items removed, does that look like the scene as you saw it on November 1st, 2022? The same hallway that is?
It appears to be the same.
Okay,
hallway.
so if I showed you Can you see a tape measure in that, in the defendant's exhibit 29?
Yes, sir.
I showed you that. You don't have any idea, I guess. How much, what's marked on the tape measure?
Where it stops at 10 feet.
Yeah, so fair, to be fair, you didn't take this picture. So, I'm sorry.
No, I did not.
But if I were to tell you that these match up and it's a 10-foot ceiling, would you quarrel with that?
No.
Okay. So it's a little bit taller than the ordinary ceiling. Fair enough?
Yes.
Judge, I'll offer. Now, I don't need to offer, he testified.
Okay.
You remember, once you climbed up on the ladder, having looked at that video, do you remember, did it take you a minute to find something inside the vented area?
It was pretty quick.
Remember having to feel around for it?
I did feel left and right, as I stated earlier. Yes.
And on the video, do you say, I can't feel anything?
I'm not sure if that was after I'd already found it or if I was saying I don't find anything else.
Okay.
I couldn't tell at what point that was.
Okay. And what did you say? What were your words when you finally found it?
As stated on the video, I said it's hidden pretty fucking good.
Okay, hidden, pretty good.
Yeah.
Okay. And did you see Investigator Pettis in that picture?
I believe he's one of the ones in front of me. It's very blurry though.
Yeah.
Can't tell.
Okay. Have just a moment, John.
Yes.
That's your two.
Oh, it's fine.
Yep. I just got, I can just give it to you.
We have to play for you, now you have to play.
I think we play. I think you all pick one.
No. Oh, you think? Investigator, you said in your report, I did not discover or recover any other evidence.
Correct.
Okay. Other than that P10.
Correct.
Pass the witness, John.
State.
No further questions, Your Honor.
All right, is this witness excused or subject to recall?
Excuse from the state, Your Honor.
I think he's excused, Judge.
All right, thank you.
Thank you, Your Honor.
Those little fellas take that back to the property room, but I think this is what this is the only thing we answered. This is P10.
I thought you were trying to get, just reminded me, he said it was pretty fucking
We don't have any other witnesses, Your Honor.
All right.
So he's gonna keep everything?
Except for that P10.
Just the narcotics.
Oh, just this?
Just that. But then everything else is going back. 'Cause
So
we-
we just need to, he just needs to fill this out to
Okay.
give it to me,
Okay.
and I'll sign up on it.
And I was gonna argue that trying to solve this now. That they're. Consider it as going down.
All right, this is going to be the state's last witness. Do y'all anticipate calling any witnesses, or you're just going to offer into evidence the character letters?
We have one other item to offer. It is a lab report that I've given the state. And in fact, I sent it to you as well by email. It's P27.
All right, if I could see that,
Yes, ma'am.
because I haven't received that. Is there going to be any objections to P27?
No, ma'am. No objection.
That's right, the one we get to.
All right, and this is Mr. Meyer's report, correct?
Yes, ma'am.
All right. So while they're doing exchanges, I can tell you, I am gonna order him to do a UA today. Is he ready to do a UA today?
We can, we did one yesterday. Are you aware of that?
Yes.
Okay.
All right, so we'll do a UA today.
Yes, Your Honor.
So I'll let them do the exchange, and while they're doing their exchange, are you ready to do the UA now?
Yes, Your Honor.
All right.
I'm gonna go get the deputy to pick up these other items. Judge.
All right, I'll give you a chance for y'all to do that. And I will be right back.
Just to let you know, before we get on the record, Your Honor, we can't find state's P9, which is the drug ID report. So I've talked to the defense and they don't have an objection to me offering another copy as state's P9.
All right, so we'll go on the record.
We have no objection to just what Mr. Wilkins said, to him offering that as a substitute for wherever the other one went. But of course, we still maintain our objection to the evidence itself pursuant to our suppression issues.
All right, and so so the record can be clear, P9 that the state is offering, that is an exact duplicate of the previous P9 that was admitted. Is that correct?
Yes, ma'am.
All right, then that will be admitted over defense's objection. All right, the state, do you rest?
Yes, ma'am.
Defense?
Now that they've rested, we submit, as the court mentioned before, as it relates to this extraneous offense, that there is insufficient proof to establish beyond a reasonable doubt that John Meyer engaged in the offense of possession of a controlled substance, namely methamphetamine, which was the only substance tested, the only evidence that there is, on November the 1st. And I've got some other authority for that. If you'd like to hear argument on that, I'm happy to do that. But that's where we are right now. And I didn't want to let them rest without me making that argument.
Okay. All right. So the court has heard, the court doesn't necessarily need argument as far as the extraneous offense. I've heard all the evidence, and if both parties are ready, I'll make my ruling with regards to the extraneous offense.
Yes, I mean, I think guess in response to that, I would just say all we need is a scintilla, and I think we've gotten past that, Judge.
All right, thank you. So with regards to the extraneous of offense, the court is going to find that as it relates to the extraneous offense that was admitted by the state, that there is not evidence to prove it beyond a reasonable doubt. And so that's the court's ruling with regards to extraneous offense.
Very much, Judge. We would offer, if it's now our turn to
Yes,
start
it is.
our case.
The state you rest, correct?
Yes, Your Honor, we rest.
We offer P1 through 12, which are the character letters that the court has seen, and we previously provided copies to the state. You have my letters.
Just one moment. And there are no objections to the exhibits. And what were those exhibits numbers?
1 through 12, Judge, inclusive.
Yeah, no objection to any of those, Judge.
All right, then defense exhibits P1 through 12 is admitted without objection.
Okay. And then we have P27, which is a lab report from a urine specimen collected from John Meyer on March the 26th of 2024 that shows everything tested negative.
All right, any objection?
No objection, Your Honor.
All right, then that exhibit would be admitted without objection.
No. Ma'am?
April 26th.
No, March the 26th is what I meant to say. It was a week or so ago. I apologize. I think we're all tired. And anything else to offer? Judge, I think with that, then we rest.
All right, and the court did ask for Mr. Meyer to provide a UA for the court, and the defense, you did not object to that, is that correct?
We did not, no, Judge.
All right, any objection to Ms. Abrams informing to the court of the results?
No, ma'am, not at all.
Judge, it was a negative.
All right, and the court will hear argument if both sides close.
We close, Your Honor.
And we close as well, Judge.
All right, court will hear brief argument.
Your Honor, I'm asking you to save the defendant's life, Your Honor, and I'm asking you to do that by sentencing him to prison. I think from what we've seen, both the guilt innocence phase and in the punishment phase of this trial, the defendant's in the fight of his life, and he can still win. He can still win against these drugs, but he needs your help. He needs to be incarcerated in order to beat this addiction. Your Honor, the police served the first warrant in August. The defendant was arrested And then just a short time later, the police served another warrant and found even more drugs in the house. And so I think he's shown that he's not a good candidate for probation, Your Honor. And I think the best way that you can ensure that he gets the help that he needs is incarceration, Your Honor. So that's what we're asking for today.
All right, and defense, what are you requesting?
Judge, we're requesting that you accord Mr. Myers probation, and I'd like to make some argument if you don't mind. Or
Yes.
Okay, thank you. In relation to the pre-sentence investigation report, if I might comment on that, just a couple of things that I want to bring to the court's attention. Mr. Meyer did not give his own explanation of what occurred, but that was at the advice of his lawyer because we had the pending case.
Mhm.
And he has no prior criminal history. There is one thing on here that it's on page 3. It says victim information and it says none. And I would just like to say an argument that I don't think that this has been a victimless crime, because I don't think that, I know how Mr. Meyer has suffered from a standpoint of shame and contrition for his behavior. He's going to walk out of here a convicted felon, and that's something he never, ever envisioned in his life. And so it is not a victimless crime. He has been a victim of his own commission. He has his own business. He is a college graduate. He graduated from Brandeis University, magna cum laude. I don't know that you're ever going to see that in your history on the bench of many people that have a college degree that graduates magna cum laude, especially from a university with the prestige of Brandeis. We know from Mr. Larkovic that John's wife and 3 children moved from the home in 2017. And the PSI on page 6 indicates that John began his use of methamphetamines at the age of 57. And if you add that up with his date of birth, that would be 2019. So shortly, within, I guess, a couple of years after his wife and family, he took up this terrible habit and engaged in it. And it has led him to where he is now. But it was something that came late in life. And I think that it's probably attributable to the separation that he had from his wife and family. He has been evaluated by your probation department. And on page 7, it says that he is a low-level risk or should be supervised at a low level, which certainly I think lends more toward probation than toward incarceration. They have any number of programs listed on page 8 that they believe that would benefit John in his therapy and treatment and counseling. None of those include incarceration. I believe that the methamphetamine dependence that he had, which led him here, has not had any consumption of methamphetamine since September of 2023. And now he has submitted at least 3 negative UAs. It's clear that he is, I don't think that incarceration is needed for him to overcome this addiction. And I believe that they said that he had had no prior treatment. So I think treatment is, in fact, would be the first alternative for the court. And I don't want to belabor the point, but I would just like to say, Judge, I've been doing this a long time. These are 12 letters that are heartfelt, that are people that love and believe in John Meyer and believe that he can be a productive member of society who does not need to be incarcerated. I read these letters from his children. He's got 3, Caitlin and Megan, and then John Zachariah Myers. And one of them, John, right now is a double major at Madison University. This man has been a productive member of society. He's got children that love him, that care about him. And every one of these letters talk about how good of a father he was and how he went out of his way to be a good father and to provide for them, and not just provide for them in a financial or physical means, but also to provide for them on a social and emotional means. When they had issues that they were going through, he was the one that would sit there and read with them at night and talk to them about their issues with anxiety. He would help his son with his weightlifting and get up at 4:30 in the morning to help his son accomplish the goals that he wanted to in that endeavor. We know that John, from his sister, Heidi, we know that John, as I mentioned before, graduated from Brandeis University, that he had some struggles before with learning disabilities, but he was able to get past those, that he lost his father at a very early age when he passed away from cancer. And John recently, or more recently, I should say, lost his mother. And when his mother was sick, he moved back to Hawaii to be with his family and to take care of his mother when she was an invalid and in her last days and months. You also have a letter here from Carol Graff, who is his cousin, who talks about how they had an extended family and thought about how John was always very thoughtful and very generous. And then we included in this, Judge, the article that was printed. I'm sure you read that in Hawaii, talking about the Meyer family and how it is a big and kind and loving family. And then finally, we have a number of letters that are from individuals that John has interacted with. And every one of them talks about John's generosity and his willingness and desire to help people who have less than them. One of them talks about the letter from Jason Manley, talks about how John found a man who was homeless, who had lost everything in a storm drain, and John bought the man clothes, gave him a meal, and John even gave up his own hotel room so the man could have a warm place to stay. We know from Mike Schultes that John was active in Habitat for Humanity and the Wounded War Project in Central Texas, and that at one time he went out and bought 26 separate generators for individuals who had the need for those, and he gave them away free out of his own, the generosity of his own heart.
All right, and counsel, just so you know, I read the character letters. My mind's a steel trap, so I remember all of that and what he did for Habitat for Humanity.
Okay, and I don't want to belabor it, but I mean, I've done this a long time, and I've never had anybody that had letters like this. And I want to impress upon the court that hope that you're impressed with him as well. This is a man who's, like I said, he is ashamed, he is humbled, he is contrite, and I think that the only yes, ma'am. Okay, thank you.
No problem. All right, and has anybody completed a trial court certification?
No, ma'am.
All right, if you all can complete that with him, and then I'll make my ruling.
Yes, ma'am. And do you see it somewhere so I can grab it?
Oh, yes, it should be up there.
Thank you.
And then we're off the record. Here's my question. In the trial, I remember 3 people sitting on folding chairs when the police entered the residence. What were the names of those people? Because I know it wasn't brought up in trial because it wasn't a part of the trial.
David Alderete.
All right, so David Alderete, is that Aldarette?
Alderete, yes, ma'am.
1 T?
Yes, ma'am, yeah.
I'm sorry. So you think it's ALDERRE?
Yes.
All right, and who else?
Let me just pull up the police report here, Judge.
I'm looking too, Judge. I'll find something.
Michael John McKenzie, which is McKenzie.
McKanzie.
Kenzie. Yes, ma'am.
Okay.
And then John Sparks wasn't one of the guys in the folding chairs, but he was at the house both times.
Okay, what's his name?
John, John, and then Sparks is SPARKS.
Okay.
And I'm looking for the female's name, Judge.
Go down for a little below, which says defendant right there.
I mean, Theta Reyes was the woman that, okay.
Yeah, I have that one.
John Sparks.
John, yes, sir.
This one.
Oh, that's yeah, there's a Kelly Couples, KELLI. Couples is CUPPLES. Then there's Melissa Yanez, which is YANEZ.
All right, anyone else?
I'll find just a minute the person on the folding chair, Judge. The last person on the folding chair. Thank you.
And I would know these names except for they were never introduced. And they were not introduced because it was not a part of the case.
That name, Judge, is Darian, spelled DARIEN. Sandoval, SANDOVAL.
So those are all of the people. I have Theta Reyes, David Alderete, Michael John McKenzie, John Sparks, Kelly Couples, Melissa Yanez, and Darren Sandoval.
Yes, ma'am.
All right. And does your client have any grandchildren?
Grandchildren?
No, ma'am.
Okay. All right. We're back on the record. This is the court's ruling. The jury having found you guilty of count 1. And the court will note for record count 1 is a possession. It's not an intent to deliver. It's a possession of a controlled substance, penalty group 1, 4 to 200 grams. Court will sentence you to 10 years in the prison, suspended and probated for 10 years. There's to be ISF cognitive. You're going to be in custody for that. There's to be regular reporting by Zoom or in person. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. There are going to be field visits by probation upon release, 1 time per month until further notice. There's to be no contact with Theta, THIEDA Reyes, David Alderete, Michael John McKenzie, John Sparks, Kelly Couples, Melissa Yanez, Darren Sandoval. There's to be no unsupervised contact with minors. There's going to be the UA hotline upon release with at least testing once every 2 weeks until further notice. And of course, probation, if you feel as though that should be changed after 3 months, then the court will consider it. There's to be 200 hours of community service restitution. If you wish to do community service hours, you can do it. Or I do allow sometimes people to pay that off, but it's at $7.25 per hour. I usually suggest the San Antonio Food Bank because they usually need money for food. But if there's someplace else you wish to donate, then you can, but it'll have to be something that's approved by probation. There's to be no possession of firearms. There's to be a destruction of forfeit of all seized firearms. Of course, if that's something that's going to be used in another case, the court understands that. So if it's not being used in another case, then those are forfeited and they are to be destroyed. There's going to be 90 sober meetings in 90 days upon release from custody. While in custody, we can do the MIC evaluation. Once released from ISF Cognitive, there'll be intensive outpatient treatment. I'm going to run a referral to felony drug court. Probation, is there anything else? All right, so with regards to the referral to felony drug court and the ISF Cognitive, the ISF Cognitive must be done. But with regards to the referral to felony drug court, if felony drug court accepts them in their program, then they will be in charge of his conditions and they may decide what I've given him is not something that he needs and they may do something else with him. All right, Mr. Meyer, is there anything else you need from the court to be successful in this probation? All right.
I just want to make sure that I'm right. What does the ISF cognitive mean? Does that mean he goes into custody
Yes.
today?
Yes.
Would the court consider having him sometime to report?
No.
Okay. Would the court consider setting a bond for appellate purposes then?
All right, once you file the motion, the court will review that. Yes.
I think theta is, I'm sorry, Judge, it's a THIDA, I think. I don't know if that's, I might have misheard that, but.
Okay.
Judge, I do have a question.
Yes.
So do you want the felony drug court referral first, and then if he's not accepted, say that?
Yes. And what I can tell you all with the felony drug court referral, you may want to talk to the judge over there. But since today is Tuesday, they may be able to get it done before the week is out and let us know before the week is out if they'll accept him.
And if they will, does that cancel out the ISF or is it ISF is still there?
No, that will potentially cancel it out. You all will have to speak with Judge Glenn because what ends up happening if he's placed in felony drug court, then felony drug court knows they have my permission to change the conditions that I've set within reason. And when I say within reason, those no contact orders, they're not to be changed. But as far as the ISF cognitive and the MIC evaluation, if they deem he does not need that, or if they have something else they want him to do instead, then they have my permission to always do that.
May I ask then, would you withhold imposition of your sentence until tomorrow? He's got a home that's nobody's in, it's locked, it's not locked up, it's uncared for. And if we can just come back tomorrow and start, I think that we'd be better off as far as the drug and also the drug court referral and also getting a motion to you to maybe set a appellate bond if that's what we choose to pursue.
No.
You won't?
No, but I will tell you, Judge Glenn is here till 5.
Where, I don't know where Judge Glenn sort of lives in the courthouse. I know.
All right,
Judge
so
Glenn
so
is-
just 1 second. Let me finish with the sentencing
Yes,
and then I'll give you all of that information.
Judge, it's THILDA, I'm
I'm
sorry.
not sure that,
All right, so everyone, stop. Because all of the chatter back and forth, the court reporter is taking it down.
Sorry, Judge.
I base how you spell her name based upon, I believe, what was in the search warrant. So if there is a correction, if you all will let probation know, and the correction will be with probation for the spelling. But I'm assuming your client knows who Theta Reyes is. He's not to have contact with her.
absolutely.
All right. So, Mr. Meyer, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorneys? Did you understand it? And did you sign it? Thank you. I'm sorry?
Yes, I do.
All right, so you do have a right to appeal because this was a jury trial. Your attorneys will explain that to you. Now we're off the record. All right, Mr. Meyer, in this court, to be successful on probation, communication is key. If there's an issue, let your probation officer know. If you feel they're not addressing it, we're usually here Monday through Friday, except for holidays and for weekends. Now, with regards to felony drug court. Felony drug court is located across from the Bexar County Jail. They have their own